Please join me in welcoming Mr. Dave Roland.
Thank you for that introduction. I don't know if you all have ever heard this song. It's called Freedom by the Isley Brothers, and it is fantastic. Go look it up on your app of choice and give it a listen. It's wonderful. It sums up my general philosophy when it comes to how people should be allowed to live their lives. The basic idea is they should be able to go where they want to go, eat what they want to eat, learn what they want to learn, love who they want to love. That's the basic idea of individual liberty. So, tonight, we're going to talk about constitutionalism and freedom, because how do we protect this kind of liberty, this kind of freedom that this song is talking about? If you want to protect it, it's really important that you have a set of rules that's going to bind the people who are running your government. So I wanted to start off with a quote that some of you may be familiar with. Do we have any political science majors in here? Nobody. Okay, all right. So maybe you won't be familiar with it. This is a quote from Federalist 51. You may not remember, but the Federalist Papers were a series of essays that were written by John Jay, Alexander Hamilton, and James Madison when they were trying to sell the American people on the idea of a United States Constitution. Not everybody thought that it was a good idea in the first place, and so they had to try and explain, what does this Constitution do? What does it mean for us going forward? Why is this something that you should support? So Federalist 51 has what I think is one of the most profound quotes in all of political philosophy, and that's where we're going to start. It says, if men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. But in framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. Okay? Well, that's the challenge, isn't it? If you're going to invest people with authority over other people, how do you give them enough power that they can do what needs to be done to ensure peace and safety and order, while at the same time making sure that the government does not overstep its bounds and become tyrannical? Let's start off by talking a little bit about the idea of a constitution. Government is something that we really take for granted. I had an appointment down in Jefferson City back a couple of months ago, and I took my 5-year-old with me, and we ended up right across the street from the state capitol, and I started trying to explain to him, this is where all of these elected officials go, and they make the laws that we live under and that sort of thing. And it was like, water off a duck's back. He just, laws and stuff, that's adult talk. He just kind of takes all of that for granted. But I think a lot of people take the idea of government for granted. It's just something they've always lived with, and they don't think too carefully about why the people that make these laws actually have any authority to do that. Why does this set of people get to impose rules on you that if you don't follow, you could end up sitting in a cage for a couple of years? Constitutions explain why the person who is in charge gets to be in charge. They explain what authority, what powers they are allowed to exercise over each other and under what circumstances. And, quite importantly, they also determine whether there are limits to the powers that these authorities can exercise. That's what a constitution is supposed to do. It's supposed to define, it's supposed to answer all of those questions. So for most of human history, political authority rested in the hands of a very limited group of individuals, and most of them held their position through the exertion of military power and or they claimed divine authority. They said, the gods or God have given me this power, therefore you have to do what I say. That's just how human civilization operated for thousands and thousands of years. While many societies developed written legal codes, they were usually created and administered by warlords, kings, and emperors who ruled over the people. And the rulers frequently did not consider themselves bound by the laws that they were creating for their subjects. Traditional Western thought held that human society was linked together in a great chain of being in which most people had no particular rights that were worthy of respect, but rather they were bound to live as subjects and servants of their rulers. You had a place in this great chain of being, and it was considered an affront to God to try and change where you were in that scale. If you tried to raise your station, people would consider you to be defying God. You were made to be in this place in your society, and you should be content with that. The modern concept of constitutionalism started to question these assumptions. The assumptions about the great chain of being, the assumptions about rulers having a divine right to exercise authority over others. And this idea developed most rapidly in England. You may remember hearing about the signing of Magna Carta in 1215. A group of nobles got together. They were unhappy with the king and how the king had been treating them. And at sword point, they said, here are the rules we expect you to follow if you're going to remain our king. And they forced him to sign it. Well, this was a relatively novel idea. The idea that subjects could require their monarch to submit to rules of the subjects' choosing. So that's one of the reasons that Magna Carta was a phenomenally important document in the history of Western civilization. It meant that the English monarchs were no longer presumed to have the sort of absolute power that most European royals claimed for another 600 years afterward. Now, through the Middle Ages, the balance of power between the British throne and Parliament evolved into this rudimentary constitutional system. But here's the thing, the principles of the British Constitution were mostly unwritten. Like when we think about the American Constitution, one of the defining images is all of these old white men gathered around in a room talking, sharing their ideas, coming up with this document, and then we have the actual document of the Constitution. You can go to the archives in Washington, D.C. and look at it for yourself. That's not the British Constitution. It's mostly unwritten, but it was nonetheless assumed to have a binding authority on the British monarch. Parliament became so powerful under this system that in 1649 it tried and executed King Charles I for treason against his own people. That's the extent to which England had gone to divorce itself from these traditional historical notions of how rulers got their authority and what the extent of the ruler's authority was. After a decade in which England functioned as a republic, the monarchy was restored in 1660, but there was a clear understanding that the cooperation and advice of Parliament was an indispensable element to the continuing authority of the monarchy. So this British constitutional system was the backdrop against which the American colonists began to establish their own government. So what we just talked about, these incidents, they happened squarely in the middle of the 1600s. If you remember, the first British colony in the United States was settled in 1603 in Jamestown. Then you had the Pilgrims set up in Plymouth in 1620. So that's kind of the time frame that we're talking about as far as these ideas percolating in British society and how they were influencing the American colonists. So as the American colonists were setting up their own governments, they widely chose to take an unprecedented step, and that was formalizing the foundational principles and structures of their governments by putting them into written documents. Again, this was novel. It had not really been done before. So the first rudimentary example was the Mayflower Compact of 1620. The Pilgrims voluntarily and deliberately formed themselves into what they termed a civil body politic, empowered, and this is a quote from the Mayflower Compact, to enact, constitute, and frame such just and equal laws, ordinances, acts, constitutions, and offices from time to time as shall be thought most meet and convenient for the general good of the colony. This was followed 19 years later by the Fundamental Orders of Connecticut. And the Fundamental Orders became the first, what we would consider the first modern constitution. It was particularly notable because in the Fundamental Orders of Connecticut, they specified that the foundation of authority for government in that colony was laid in the free consent of the people. So I'm sure you guys are familiar with the Declaration of Independence. And this, of course, is one of the basic ideas that Jefferson was getting across in the Declaration of Independence, that government derives its just powers from the consent of the governed. But again, it's hard, 240 years down the road to wrap our heads around what an earth-shattering shift that was in assumptions about how government gets its authority. If the people decide they don't like who's ruling over them, they get to just tear it up and start over, was what Jefferson was saying. Now, he wasn't the first one to come up with this idea. Like I said, the Fundamental Orders of Connecticut started laying that foundation in terms of American constitutions. But over the years, between 1639 and 1776, that whole idea of the just powers of government residing from or growing from the consent of the governed started to kind of pervade the British Empire. It spread out and it became the foundational principle of the American Revolution. But perhaps more importantly, after the Fundamental Orders of Connecticut, Americans developed a profound commitment to the idea of writing down their constitutions and having them carefully reasoned out and then approved by a collection of citizens as being absolutely necessary in regard to any large-scale government. So anytime that you got above the size of a city, if you're talking about a county or if you're talking about a colony or what would eventually become states, it was just assumed. If we're forming this new government, we've got to have a constitution that's going to establish those terms under which the people consent to be governed. I think that this is the point where I need to point out three of the truly momentous innovations that distinguish American notions of constitutionalism from their English predecessors. So we've already covered the idea that these constitutional principles should be debated and then written down. We've talked about that innovation and that they should be submitted to a vote of the people themselves or the people's elected representatives. So this was not entirely unique. There were parts of the United Kingdom's constitutional tradition that had been reduced to writing and adopted by Parliament. But in the United States, constitutions were intended to be a concise, comprehensive statement of the governing principles that would then be accessible not only to legal professionals, but to laymen as well, to the ordinary citizen. And that's one way that it differentiated from the British tradition. The second major innovation that I think is worth pointing out is the idea that freedom was humanity's natural condition. Again, this is directly contrary to the general assumption for most of human history. But in America, it just came to be taken as a given that people are born free. It's only later that they're reduced to some condition less than freedom. Americans also assumed that although people had chosen to sacrifice some degree of their natural freedom in order to protect themselves from threats to life, liberty, and property, there were certain kinds of freedom that no government could legitimately intrude upon. That also was a brand new idea. Under the British constitutional system, the Constitution bound the monarchy. It did not bind Parliament. So under the British constitutional system, if there was some restriction or some right that people were enjoying that Parliament decided it no longer wanted, all Parliament had to do was pass a law and it's gone, it's done. Americans said, we don't agree with that. There are certain natural rights that no just government gets to take away from the people. Now, this idea actually has some pretty ancient roots, and I hope you'll indulge me a little bit by delving into those. There's a famous Greek tragedy called Antigone, and it tells the story of King Creon of Thebes, who forbade the burial of a man named Polynices, whom the king considered a traitor to the city. But Polynices' sister, Antigone, believed that the gods required you to bury your dead. And so she felt like she had a divine obligation to bury her brother in spite of the king's direct order to the contrary. So she does, and then he throws her in jail and puts her on trial. Why did you defy my authority? I'm the king. You've got to do what I say. And she speaks up and she says, no. The gods have decreed that this is what I owed my brother, and no one, not even you, King Creon, can tell me that I'm not allowed to do what the gods have required. So there's this ancient historical image of natural rights, of people having an obligation that transcends any human law. By the way, it didn't end up well for Creon. He ultimately puts Antigone to death, and then he suffers his own death. It's very Greek and tragic. So, after this, and still ancient days, roughly 2,000 years ago, Cicero, who was a Roman political philosopher, and other Roman philosophers, they began asserting that all people are born free by nature, and that if humanity had remained in a state of nature, then they would all be essentially equal. So this idea has got these ancient roots. Then in the 16th and 17th century, European philosophers started to explore this concept of natural rights. And John Locke is the figure who ultimately ended up being most influential on America's political thinkers. John Locke had argued that although people are naturally free and equal, they surrender part of their freedoms to the government to better enjoy their life, liberty, and property. And this was echoed almost word for word by Thomas Jefferson in the Declaration of Independence, where he says, "It is self-evident that all men are created equal and endowed by their Creator with certain unalienable rights that include life, liberty, and instead of property, he said the pursuit of happiness." But you hear the echo of John Locke. And almost every American Constitution that was written after the Declaration of Independence expressly stated that the governments that were being created could not deprive people of life, liberty, and property without first affording due process of law. Now, due process of law does not mean the way that it did in England, that you just have to go to the lawmaking body and get them to make a law. It means beyond that, you're talking about natural law. So even if the government follows all the procedures to adopt a law, there is still an idea of substantive due process that's owed to every citizen, and you cannot take away the rights that they naturally accrue to themselves from their Creator. So these concepts were a significant departure from the English constitutional system. Locke was also the figure who first started to challenge the idea of parliamentary sovereignty. I talked a little bit earlier about how there was an assumption that the English Constitution limited the power of the monarch but not the legislature. And Locke started to chip away at that. Locke was writing in the middle of the 1600s, so a good 100 years before the American Revolution. But he started to chip away at a lot of those assumptions that people had about the nature of government, particularly under the English constitutional system. Consequently, he was arguing that because people are born free, and because the way that governments come into effect is that the people make an agreement that they will each surrender a part of their liberties in order for the government to safeguard their broader lives, liberties, and property. Locke argued that whatever rights they were surrendering had to be the extent of the authority that the government could exercise. In other words, the government can't use an authority that I never had over my neighbor. You follow where I'm going with that? So if I don't have the right to walk over and punch my neighbor in the face for no reason, I can't surrender the right for the government to go over and punch my neighbor in the face for no good reason. Okay? It's a right I never had, therefore I can't give it to the government. So Locke starts reasoning that because the rights or the powers that the government exercises are things that have been surrendered by the people, the general power of government is limited by that authority that we can each exercise over each other in a state of nature. I hope that's not too in the weeds. But the upshot of it is that Locke argued that in order to be legitimate, laws must apply generally, they have to afford equal protection to all, and they cannot operate retroactively. And crucially, Locke recognized that for these limitations on the power of government to be made effective, you've got to have entities independent of legislative control that could, if necessary, declare these improper legislative acts to be void. So one of the features of the British system was that legislative bodies frequently doubled as judicial bodies. They not only made the laws, they also decided how those laws would be interpreted and applied. And Locke looked at this situation, he's like, this is terrible. Because if the legislature makes a law, they're never going to consider it void. They're never going to say, oh, well, we overstepped our bounds. They're always going to think that they had the proper authority to do what they wanted to do. And so Locke says, in order to make sure that we are holding the legislature in check, you need to set up a whole different group of people to evaluate the laws that have been adopted. And that other group of people, the judiciary, are going to have the authority to come back and tell them, no, you've gotten beyond your legitimate authority. You cannot do this. The act that you've tried to commit is void. So Locke started to deal with this idea of separating the powers of government. The third major innovation, and it's tied into Locke's theories of government, was that Americans began to insist that the surest safeguard of individual liberty was to have this division of power within the government. The idea, however, found its fullest expression in a French political philosopher named Montesquieu. Montesquieu wrote a work called The Spirit of the Laws, where he talked about different systems of government. And one of the things he settled on was that looking at the Roman Republic and then looking at the British constitutional system, he said the reason that these systems worked to the extent that they did is they had divided government in some way. So in Rome, you had a division between the Senate and the consuls. In Britain, you had a division between Parliament and the throne. And he says that's really a great idea. And then he fleshed it out even more specifically. He says, if you look at it, there are three basic functions of government. You have the making of the laws, the deciding what the laws are going to be. And then you have the people that are responsible for putting those laws into action and enforcing them. And then you've got the people that are supposed to decide whether the laws are being applied appropriately, whether they're being interpreted correctly, and then whether they're being applied appropriately. So he says there are three basic functions of government: legislative, executive, and judicial. And in order to safeguard liberty, you've got to keep these separate from each other. Because the moment you start letting an executive official exercise legislative authority or judicial authority, this accumulation of power, this centralization of power is going to, by sheer force of human nature, lead people to behave tyrannically over the people that are subject to their rule. And so he says, keep them separate. And this was hugely influential on the framers of the American Constitution. When they were thinking about how they were going to set up their new system, they looked at Montesquieu and they agreed that we want to avoid centralization of governmental authority at all costs. What we want is for each branch of government to check and balance the other branches of government. So, I read at the very beginning from Federalist 51, that paper went on to explain that the goal is to ensure that ambition is made to counteract ambition. They said what we want to do is divide the whole of governmental authority in several different ways. They didn't stick with just Montesquieu's idea of dividing it into three branches. They went even further. They said, first off, we're going to have a federal system. All right? So out of the entire universe of legitimate governmental authority, we're going to give the central government, the new national government, a handful of carefully enumerated powers. That's all they get to exercise. The rest of the authority goes to the states, and the states are going to have their own systems as well. But then what we're going to do with this central government is we're going to divide it even further. We've got the legislative, executive, and judicial, but we're going to divide the legislature again, because the legislative branch was thought to be the most powerful, potentially the most tyrannical. So they said, we're going to divide it again. You're going to have a House of Representatives and you're going to have a Senate. And in order to get anything done, these two have both got to agree. All right? But they thought it would create too many problems if both houses were chosen in the same way. So you may not know, but when the original American Constitution was written, the Senate was not elected directly by the people. The Senate was chosen by the state legislatures. And so there was a reason for that. The idea being that having one group of people choosing one body, the House of Representatives, and a different group of people choosing the Senate, the people chosen are going to have different motivations, different aims, and that will get ambition counteracting ambition, and it will be most likely to prevent the centralization of authority and the institution of a tyranny. When the framers got all of this in place, the people ultimately decided to ratify the Constitution. And so then the question becomes, how has it worked in practice? And there are lots of different ways we could talk about how it's worked in practice, but I thought I want to stick with an issue that I think is very, very pressing right now. And so what I want to talk about is whether or not the system that the framers established would allow, for example, the president who holds the White House to say, we're going to require every business with more than 100 employees all over the country to have their employees vaccinated. Okay? Now keep in mind, Congress has not passed a law that says this is what we're going to do nationwide, right? So ordinarily, we would think that what the president has tried to do is an exercise of a legislative function. And according to Montesquieu, according to the idea of separation of powers, this is a terrible idea. We shouldn't allow this to happen. But who's going to tell them no? Right? Which branch of government is supposed to play that role? The judiciary. They're supposed to tell them no. Well, here's where we've got a little bit of a conundrum, okay? The separation of powers worked really, really well up until the early part of the 20th century. And in the early part of the 20th century, you had the federal government trying to respond to the Great Depression. And one of the big trends at the time was what they called the rule of experts. The idea that was very trendy, not just in the United States, but all over the world, was rather than having these legislative bodies considering all these laws, making all these rules, let's set up administrative agencies, and then the legislature will empower the agencies to do whatever they think is best to deal with whatever's in their jurisdiction. So at first, the Supreme Court looked at that and they said, whoa, 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 whoa. Congress, you can't do this. What you're doing is trying to delegate a legislative function to executive officials. That violates the principle of separation of powers. You can't do it. But they changed their minds. There was one case called Schechter-Poultry where they struck down this attempted delegation. And then after that, for 80 years, more than 80 years, the U.S. Supreme Court has let Congress broadly delegate its powers to these executive agencies. So, as it sits right now, as the case law sits, in all likelihood, if the Supreme Court follows its precedents, they would say, hey, look, Congress gave the Occupational Safety and Health Administration the authority to do whatever they thought was best to secure health and safety in the workplaces. This is related to health and safety in the workplaces, therefore, they've got the authority to do this. But here's the really interesting thing. In 2019, the U.S. Supreme Court considered a case where Congress had delegated to the Attorney General's office the ability to decide who a new law was going to apply to. It was a sexual offender registration law. And they said, you know what, we're just going to let the Attorney General decide whether this law is going to apply to people who were convicted of their offense before the law was passed. It's in his hands. So how many justices do we have on the Supreme Court? 9. So ordinarily, if you're going to win a Supreme Court case, how many votes do you have to get? 5, right? The winning side in this case got 4 votes. Okay? This was right as Justice Kavanaugh was being confirmed, so there were only 8 judges sitting on the court at the time. 4 of them, the 4 left-leaning judges, said, yeah, there's nothing to see here. This is perfectly fine. We've ruled that this is okay for 85 years. There's nothing new here. 3 of the judges, Justice Thomas, Justice Gorsuch, and Chief Justice Roberts, said, we've got to revisit this. Clearly, we've gotten away from these founding principles, this fundamental idea that in order to secure liberty, you've got to have separation of powers. We've got to revisit this. Justice Alito concurred with the liberals, but he said something very interesting, and I'm going to read you his concurring opinion in its entirety. It's short. He said, there can be no liberty where, that was from the primary dissent. He said, the Constitution confers on Congress certain legislative powers, and it does not permit Congress to delegate them to another branch of government. Nevertheless, since 1935, the court has uniformly rejected these non-delegation arguments and upheld provisions that authorized agencies to adopt important rules. If a majority of this court were willing, I would support reconsideration of that rule. But because the majority is not willing to do that, it would be freakish to single out the provision at issue here for special treatment. So Alito says, if we can get other people on board, let's revisit this. Let's undo 85 years of precedent. But there weren't 5. There weren't 5 votes at that time. What's happened in the 2 years since? Justice Kavanaugh has joined the court. In all likelihood, he's probably going to share the same perspectives that Gorsuch, Thomas, and Roberts shared. And also in that time, Justice Ginsburg died and left the court and has been replaced by Justice Barrett. So 1, 2, 3, 4, 5. So let me tell you what I expect. I think you're going to see litigation about this new White House rule. And I think the lower courts are going to be obligated to uphold what the White House is doing because 85 years of U.S. Supreme Court precedent tells them to. But I have a sneaking suspicion that when this gets to the Supreme Court, I think they're going to take the case. And I think you may well have 5 votes on the court to restore this traditional understanding of what government is supposed to be and how it's supposed to be structured. And why are they going to do that? Because the United States adopted a written constitution. Because we have built-in assumptions that when Congress tries to do something, when the government tries to do something that goes beyond what the people themselves have allowed, it is void, and it's the obligation of the courts to strike it down. So, as to the theme of constitutionalism and freedom, this is how our constitutional system was designed to work. It remains to see if it's exactly how it will work. And with that, I'll take questions. And I'll take questions on anything having to do with constitutional issues. So if you're not so interested in the non-delegation doctrine, don't feel like you're limited to that. I litigate all kinds of cases.
Do you think they'll get that case expedited to the Supreme Court?
Probably not. No.
Yeah, because there's a lot of damage that happens between now and then.
So this ties into another issue that has been very much in conversation in the last couple of weeks. This new Texas law dealing with abortion that basically creates a private cause of action for people who are suspected of assisting in the procurement of an abortion. A lot of people on the left were totally up in arms because the Supreme Court did not want to jump into that situation at that particular juncture. And what people do not understand is litigation generally just takes a long time. And it is actually quite difficult to get a court to say, we're going to prevent a particular law from going into effect until we've had a chance to hear this, because it could take years. And so I'm not going to say that it's impossible that a court might step in and tell the federal government, we're going to put a hold on the enforcement of this law until the courts have been able to work all the way through it. It's possible that they'll do that. I don't think they will. But that does not necessarily predict the outcome of the case ultimately. And you're right. There very well may be people who suffer consequences in the meantime. And I don't mean to downplay the severity of that or the difficult situation that they've been put in. But I do think that it is a feature, not a bug, of our constitutional system that courts are so hesitant to jump in and interfere in situations like this. It would be different if this was a question of first impression, but when the Supreme Court has ruled on these issues a certain way for 85 years, and they have, it is a little bit more of a hard sell to say that a court should jump in now and predict that maybe the court's going to do something different this time. So, yeah, it is a genuinely tough situation, and I'm not pleased that I have to say that we're just likely to have to deal with it in the short term. And perhaps I'm wrong. I will throw out one more thing about this. I'm sorry, I'll get to your question in just a second. There are hints that maybe the court will jump in on it, okay? So speaking of longstanding bad law, back in 1990, the U.S. Supreme Court essentially eviscerated the free exercise clause of the First Amendment, okay? Up until 1990, if you were a person of faith and a law either forbade you from doing something that your religion required or required you to do something that your religion did not permit, you would get an exception to that law. The law didn't go away, but you could not be punished if what you were doing to violate the law was a genuine act of practicing your faith. In 1990, the Supreme Court threw that rule out. And they said, look, as long as the rule applies evenly to everybody, then people of faith don't get a get-out-of-jail-free card. They're going to have to face the music. And to be clear, that opinion was written by Justice Scalia. A lot of people hold Justice Scalia up as being, this could never do any wrong kind of justice. That's not so. He definitely got that case wrong. But now that there's been this change on the court, it seems quite clear, I think, that the Supreme Court is ready to go back to the way the Constitution was understood prior to 1990. And this came up in the context of COVID rules being imposed on churches. Okay? If you go by the rule that the Supreme Court adopted in 1990, as long as the rules being applied the same to everybody, churches have no recourse. They're just stuck. But when Justice Ginsburg left the court and Justice Barrett came on the court, all of a sudden you saw the Supreme Court stepping in and telling California and New York, you are no longer allowed to enforce your COVID rules on these churches. So I think it is arguable that maybe, in keeping with what we were just talking about, how courts normally handle these things, maybe the Supreme Court was playing fast and loose with its own rules, but they were willing to step in under those circumstances, so it is possible that they might do the same thing when it comes to this new COVID rule from the White House. But as of right now, we'll just have to see. We'll have to see. You got a question?
Mine was off of hers. Like, it's going to take that long to maybe even hear the
Litigation takes an insane amount of time.
But then sometimes it seems like, probably because I'm biased, I'm only listening to this case for like the election, and then all of a sudden all these judges, they were quite responsive to things that you don't want them to be, but then when you want them to move quickly, then they say, oh, but it takes such a long time.
There are certain circumstances where cases have to be expedited. So, fun fact, 5 years ago tonight, I was celebrating in St. Louis with a client who had just gotten an election overturned because of election fraud. It's one of the very few cases in which a court actually threw out the result of an election because we were able to prove fraud. That case we filed, I think, August 23rd, 2016, and it was done with a published Missouri Court of Appeals opinion by September 16th. So when certain circumstances present themselves, courts can deal with issues really, really quickly, but that is definitely the exception rather than the rule. With elections, you've got to get people into office. You've got to know who's going to be serving, and you can't wait 2 years because that's an entire term. So that's why those cases move more quickly than others. There are another example, death row inmates. So this is actually, it's going to be a big deal. If you pay attention to legal news, constitutional news at all, you're going to be hearing about this in the next few months. One of the hot issues is the extent to which a convicted person about to face execution can have a spiritual advisor in the room with them as they're dying. And you had some states that had a rule, well, if you're a Christian and you have a Christian spiritual advisor, that's okay. But if you're Muslim or Buddhist, no, you can't. And the Supreme Court stepped in and they said, no, you've got to have the same rule for everybody. So then Alabama says, all right, well, you're just not allowed to have a spiritual advisor at all. But there was a case that just came up where it was from Texas, and the person to be executed wanted the ability to hear his spiritual advisor pray as he was about to die, and the rules said the spiritual advisor is not allowed to speak at all. And so there's this question of, can you deprive this person, regardless of what they've done, they're about to die, they're about to pay the consequences, can you deprive them of the opportunity to hear their spiritual advisor praying as they're about to die? Supreme Court stepped in. and they said, you're not allowed to execute this man until we figured this out. They ordered expedited briefing. Ordinarily, if you get a case in front of the U.S. Supreme Court, you have several months to prepare your briefs. So you start off having a couple months of your own, assuming that you're the petitioner, and then the other side gets a month and a half to prepare their briefs. Then you get a reply brief, and then you have like another window where you wait for oral argument. So the whole process takes 4 months or so, sometimes even longer, to prepare for this argument. Supreme Court says, and they made this decision last week, they said they want it briefed and argued in October or November, which is insane. Like, I cannot fathom trying to prepare a brief and then prepare to argue in front of the U.S. Supreme Court in that kind of a timeline, but when it's got to be done, it's got to be done. And so there are certainly circumstances where courts can move faster than in other circumstances, but by and large, cases take an insane amount of time. And you try and tell clients beforehand, all right, we're going to file this lawsuit. Maybe we'll get a decision from the trial court in a year and a half. Maybe we have a decision from the Court of Appeals 3 years down the line. Maybe we go up in front of the state Supreme Court or the U.S. Supreme Court 4 years from now. It's daunting to think about, and quite frankly, it's the attorney's fault. Not this attorney's fault. Attorneys generally. So the rules for litigation, including all of the timelines, they were all made before the internet. When people were having to do all of this research by hand in books and stuffy libraries. Now, I do my legal research sitting in my living room with my 9-year-old, my 5-year-old, and my 1-year-old playing in front of me. And I'm still a lot more efficient than very good lawyers that were doing this back in the 80s. There's no reason that these timelines should exist the way that they do now. It just unnecessarily drags things out. But it works for attorneys because they get to procrastinate. And judges don't feel any particular pressure. And so if it's working for the judges and the attorneys, who cares if it keeps the clients dragging along for years? I'm not saying that's the way it should be, but that's why litigation tends to take so long these days.
Yeah. The 1990 case, that's the Smith case?
Yeah. Employment Division versus Smith.
Yeah, could you explain that to the group?
I would love to.
And explain why that became a problem for Christian churches, because it's an interesting kind of sequence of events.
Let me take it back a little bit further. Okay, so this general rule that I talked about how if the law penalized you basically for a religious practice that you got an exception, that goes back to, I believe, a Seventh-day Adventist who had a religious prescription against working on a certain date, and that meant that they were not going to qualify for unemployment benefits. And so the courts initially were like, oh yeah, well, you're just out of luck there. Everybody's got to play by the same rules. And the U.S. Supreme Court said, no, wait a minute. I mean, she has a legitimate religious reason that she can't meet this qualification. She shouldn't be penalized for it. And that's when they started making these exceptions for religious practice. So we get up to the late 80s, and Employment Division versus Smith dealt with a couple of guys who worked for this branch of the Oregon government. They were Native Americans, and they practiced a peyote religion, which meant that part of their religious practice was ingesting drugs that are highly illegal under state and federal law. And so they lost their jobs. And they said, no, wait a minute. You remember this case, Lemon versus Kurtzman? We're supposed to get an exception here. It doesn't matter that it's drugs that we're talking about. This is part of our religion. And Scalia said, oh my goodness, drugs. That's one thing about Scalia and Thomas in particular. They tend to be really good on a lot of constitutional issues, but by golly, you introduce drugs in the mix in one way or another, and their brains explode. So there was a case where they had an opportunity to limit Congress's power to interfere with individuals' lives. Okay, it dealt with federal drug laws and the idea of the way the federal government exercises a lot of its power is they say, well, these things are related to interstate commerce. All right, and it goes back to this case, Wickard versus Filburn, where they told a guy that he could be punished for growing too much wheat on his own land. Congress said the federal government gets to dictate how much wheat you can grow on your own land, even if you're not going to be putting this wheat on the market. And so the farmer in that case, he says, how can this affect interstate commerce? I'm never putting this wheat on the market. I'm growing it on my own farm for my own family. Congress surely doesn't have the power to do this, right? And the U.S. Supreme Court said, yes, they do. Because your decision to consume this wheat for yourself means that you're not buying it from somebody else, and that affects interstate commerce. Fast forward to the 90s, and you've got someone who is a very ill medical marijuana patient. She was growing plants for her own consumption, and in point of fact, there is no legitimate interstate market for marijuana. And she says, how can Congress have the authority to make a federal law dealing with this particular plant that never goes anywhere near interstate commerce? Ordinarily, you would think Scalia and Thomas would be right in line with this. And they would say, no, Congress doesn't have that kind of authority. They would jump at the opportunity, but drugs. And so they said, oh yeah, Congress can regulate drugs. That's interstate commerce. One other example, real briefly, deals with free speech. Again, Scalia and Thomas, generally pretty good on free speech. But there's this case out of Alaska, and I have to laugh because it was a bunch of high school students, and just as a gag, it was when the Olympics were in Salt Lake City and they were running the torch, to try and get to Utah. So they're running the torch through Alaska. The school lets the kids out to go and stand along the torch route and cheer, and these kids raise this sign, and it says, "Bong hits for Jesus." Bong hits number 4, Jesus. Now, what does this sign mean? Absolutely nothing. It means nothing. They were just trying to be funny, right? They thought, this is a hilarious thing to put on a sign. But the Supreme Court says, oh no, you're advocating the use of illegal substances, therefore, free speech does not apply. It was an insane decision, absolutely insane decision, and it happened because when certain Supreme Court justices get even the hint, and one might say the whiff of drugs, they flip out, and their constitutional interpretation calibration goes completely awry. But yeah, so that was the case of Employment Division versus Smith, and we are on the cusp of having that overturned. One of my college classmates 20 years ago, she and I were about where you guys are right now. She is now one of the top attorneys for the Becket Fund for Religious Liberty in Washington, D.C. She argued a case last year that we thought was going to be the one that overturned Employment Division versus Smith, but the court found a narrower way of getting at the issue. But they did specifically say, we're going to come back to this whole Employment Division versus Smith thing, and I think the way that the court's set up now, I think we're going to see a revival of religious liberty, which is a very, very good thing. Let me tell you how gratifying it is to be a constitutional attorney, to practice constitutional law, and understand that your project is a decades-long project. Like, I knew going into it that some of these things that we were trying to accomplish in constitutional law legit may not happen in my lifetime. So, for example, think about the civil rights movement, okay? The National Association for NAACP, National Association for Advancement, yeah, okay. NAACP starts their efforts in the 1870s, trying to undo some of these black codes in the South. We don't get to Brown versus Board of Education until 1954. That's 80 years. 80 years of a consistent effort to try and make this one particular improvement in the law. And so the kinds of things that we're trying to accomplish, we're dealing with precedents that are decades old. One in particular that goes back to about 1874. And I just have to acknowledge there is a possibility that I will never actually see us succeed in this long-term strategy. But when you see it happen, it is incredible. I remember when I was in high school, employment division versus Smith coming down, because my family talked about constitutional issues all the time. I come by it honest. And I remember when that case came down, and then when I was in college taking a class on constitutional law, and I remember thinking, I want to help undo this. And unfortunately, I've been able to. I've been able to play some small role in that. By the way, my organization, the Freedom Center of Missouri, has a case that could yet play a role in that. City of St. Louis told a pastor and his assistant they were cited for giving food to homeless people on Halloween in 2018. This is, I'm sure many of you know your Bible. You're familiar with the book of Matthew, where one of the things that Jesus says is going to separate the sheep from the goats is whether when you saw someone who was hungry, you gave them something to eat. Kind of a big deal. And so this pastor has been doing this for 40 years, ministering to people on the streets of St. Louis when they don't have any food. He goes up and he gives them a sandwich and he says, in the name of Jesus, I want you to know that God cares about you and wants to see your needs met. Now that's a religious practice. It's also an exercise of free speech. And so when I got the word that Pastor Ray and Chris had been arrested or cited for doing this, we jumped at the opportunity. We had actually been looking for this specific kind of an issue for years because I saw it happening in different places across the country. And so one of the issues we have raised in that case is we went to the judge and we said, look, we know employment division versus Smith has been out there for all this time, but we want to preserve the question of whether that should be overturned. Maybe you can tell everyone else they're not allowed to feed homeless people. I'm not saying I want that. Maybe you can tell everyone else. But when it's someone doing what Jesus told them to do, they get a pass. So, I don't know. I do hope that employment division versus Smith gets overturned before we get up there, but we're going in front of the 8th Circuit Court of Appeals in a couple of months on that case. So keep your ears peeled for that. Do we have any other questions? Yeah, sure, that's fine.
So, in my personal opinion, I believe that the lobbyists are a big part of the corruption of the government. So, is that something that was meant to be part of our government, is having all this money poured in, and what I do is bribing people for votes, and can you address the lobbyist situation?
We won a lobbyist case in 2019. So here's my take on this. For those of you who didn't hear, she's concerned about the role of money and lobbyists in politics. I think absolutely there is a right to intervene when you have corruption. Like when you have a quid pro quo, you vote for this and I'm going to donate X amount of money. I think it gets a lot stickier when you talk about the kinds of campaign finance laws that are being passed. Because the truth of the matter is, very wealthy people are generally going to be able to find a way to influence where they want to influence. Maybe it doesn't even involve a quid pro quo exchange, but they're going to find ways to influence. It's a lot harder for people at the lower end of the economic spectrum to figure out how to deal with these rules, how to navigate these different rules.
That's the way the common people feel,
Yeah.
that our voices are not being heard anymore.
Well, so here's my concern about the way that these campaign finance laws are being applied. This case that we won a couple years ago, it was actually an ordinary citizen who was not giving any money at all to politicians. He was just very, very effective in persuading people by going and talking to them. And the lobbyists decided that he should be treated like a professional lobbyist. They said, well, you are going and spending all this time talking to people. That's basically what lobbyists do. So you should not be allowed to do that until you pay a fine, or pay a fee and report your conversations to the state, just the way that lobbyists are required to do. Well, when you're talking about actual professional lobbyists, there is a lot of money involved, and that raises at least the possibility of corruption or the appearance of corruption. But where there's zero money involved, the idea that you would tell an ordinary citizen they're not allowed to speak with elected officials unless they get permission is pretty offensive. And yet, we only won 6-5. And we lost at the Court of Appeals before we won. We lost at the trial court, went in front of, the way that it works, after you have a trial court render a decision, you go to the Court of Appeals and you have a 3-judge panel. In our case, 2 of the judges ruled against us and 1 ruled in our favor. And then we went back and there were 11 judges total on the court. And we said, we would like all 11 of you to weigh in on this. And so they granted what's called a rehearing en banc. And so after we had the rehearing, 6 of the 11 ruled that we should win, 5 ruled we shouldn't. And I thought that was a pretty straightforward argument, that you can't prevent people from just sharing ideas with their elected officials. And it was that close. I've got a case right now we just filed a couple weeks ago in Cole County. And this is one of my more conventional concerns about campaign finance laws. They get used a lot for what you might consider lawfare, where a disgruntled political opponent sues just to make life difficult on the people that they're up against. So it was a city council race. The guy loses. 2 years later, he goes to the Missouri Ethics Commission and tells them that his opponent should be fined because he put bumper stickers on the company car that his employer had given him to drive around town. Basically, they're saying if you put stickers on your own vehicle, that is a donation of something of value to your campaign that you then have to report to the government. If just putting a sticker on a vehicle or putting a sign in front of a yard qualifies as a donation that you have to report to the government, that just opens an entire can of worms. It's going to make it incredibly difficult for any but the most well-heeled of candidates to compete in these races, because poor people are not going to have a cost-efficient way of advertising their candidacy. They couldn't hope to comply with all of the reporting requirements that they're required to do under Missouri's campaign finance laws. So we're challenging the constitutionality. They fined him $1,000, by the way. Guy put a bumper sticker on his work vehicle and they're fining him $1,000. I think it's crazy. So I don't want to say that campaign finance laws are ill-intentioned. I don't think they are. I think that they have a lot of unintended consequences, and that those unintended consequences end up creating more costs than are warranted by any benefit that they actually provide. So I think I actually proposed a free market solution to this a few years back. For those who are legitimately concerned about the outsized role that money plays in politics, form a voting bloc. Get 3% of the voting population to say, we will cast our ballot in every race for the candidate who raises the 3rd most amount of money. 3% is enough to tip a lot of races. And so if the defining point of those political races is going to be who raised less money, then you're going to see a lot of politicians adjusting their behavior accordingly. But here's the thing. Although a lot of people say that they're concerned about the role of money in politics, most people aren't going to be willing to use their votes in that fashion. I think that would actually be a very effective way of affecting the behavior of these politicians. But I think that although people don't like the idea of money in politics, I think that they would not be comfortable taking that step to actually accomplish the change without creating the campaign finance laws that can then be abused. So, that's it. Any other questions? Okay. Thank you all very much.